Hi, I'm John Strohmeyer, and today we're discussing the differences between a living trust and a last will. Which one do you want to think about when planning your estate? Well, both documents can get you to the same point. What happens to your stuff when you die? The difference is going to be what happens before you die and how can they help. A last will is what most people think of as the document that they will use to control what happens to their assets when they die. Now, a last will can be changed at any point during somebody's life. So if you have a will that you write on Monday and on Wednesday you change your mind, you can change the terms of that last will. All you need to do, you can just pull out a yellow pad of paper and make a holographic or handwritten change to your will. If you make an entirely new will, it's just a new last will. If you make just a slight change to an existing will, that document is not another will. It's in fact called a codicil, C-O-D-I-C-I-L, codicil. The other option that people use for testamentary planning is a living trust. Now, the Revocable Management Trust, the Revocable Living Trust, they're different terms for the same idea. You're still going to do what a will does in that you're going to have a document that controls the disposition of your assets on your death. But what a living trust or a revocable management trust does in addition to a last will is it provides for an option to manage property while you're still alive. So a last will is only going to be effective on your death. You can change it as much as you want from the time you write it until the time you either die or lose mental capacity. A living trust you're going to set up and you can change it as much as you want from the time you write it until the time you die or lose capacity. And it's going to control the disposition of your assets on your death. But what that living trust is also going to do is, because you're going to fund assets into your trust during your lifetime, the trustee of that trust will be able to manage those assets for you while you're alive. Now, generally, people who are setting up living trusts are also setting themselves up as the trustee of their own trust. So they're in charge, but what they're doing is providing a mechanism for how to manage those assets if they lose capacity. So a person who sets up a living trust can, that if something happens to them, if they're in a coma, if they're in a wreck, and no longer able to manage their own assets, the trustee, whoever that successor trustee is, can step in and take over the management of their assets. Also, on death, they're going to avoid probate, which may be a goal that some people have. Instead of having to wait for an executor or an administrator to be appointed, the trustee of that living trust can take over and manage assets immediately on the death of the trustor. Under a last will, though, that's only going to take effect on death, and none of the provisions in there will be effective until that will has been probated and the executor takes over and starts managing assets. So both documents have their place. Both generally can be used to manage assets after death and direct the disposition of assets and payment of any taxes. The difference is going to be what happens and what control do you want during lifetime. Last will is not going to offer any control during lifetime, but a living trust will give you an option for managing assets while you're still alive and if you're incapacitated.